The court will call the first matter to come before the court this morning, which is Baxter County case CR 2017-302, State of Arkansas versus Gary Palmer for arraignment. Before we begin on this matter, the court is appointing the Public Defender's Office to represent Mr. Palmer. Mr. Palmer is before the court for arraignment on charges of possession with the purpose to deliver methamphetamine or cocaine, possession of drug paraphernalia related to methamphetamine or cocaine, and possession of drug paraphernalia for the manufacture of methamphetamine. On those charges, how does the defendant now plead?
Your Honor, he enters a plea of not guilty to all charges and waives formal arraignment.
The court, on this matter, the court is issuing a scheduling order for which will set Mr. Palmer down for trial during the week of February 26, 2018. There will be a pretrial date scheduled for January 25th of 2018, and his next court-ordered appearance date will be November 16th, 2017, excuse me. That will be the order of the court. Mr. Palmer, those dates are in a scheduling order, and at this point it's your obligation to get in touch with and stay in touch with your court-appointed attorney, Mr. Cooper. The order that I enter sets out that you are specifically ordered to schedule appointments and keep appointments, and failure to do so with the Public Defender's Office, and failure to do so will constitute contempt of court. That's the burden on you. While you're incarcerated, the Public Defender's Office will be in touch with you, but should you make bond, you need to understand that it is your obligation to stay in touch with them, and this court is not going to be sympathetic with you if you do not do that, and is likely to hold you in contempt of court. So, anything else to come before the court?
Your Honor, Mr. Palmer and I discussed his bond yesterday. Upon arriving in court today, I was given by probation and parole that they are in the process of filing 2 petitions, and with that, in case numbers 2016-348 and 2017-121. With that in mind, Mr. Palmer, bond will not be an issue, at least today, because of the parole hold.
Do they know how long they're going to have this hold on
I would have to defer to parole and probation on that, Judge.
We would not agree to a bond.
All right. So at this point, the court's not going to allow a bond. So at this point, you just need to get in touch with and stay in touch with the Public Defender's Office. All right. You may be excused. 2017-304, State of Arkansas versus Jonathan Steuben. This is for these are new charges for arraignment today. The charges are driving while intoxicated, no liability insurance, possession of controlled substance, meth or cocaine, possession of controlled substance, Schedule 6, the latter being a Class A misdemeanor, all the possession of controlled substance being a Class D felony. On those charges, have I signed a
Your Honor, I don't believe Mr. Steubinger has filled out an application.
Mr. Steubinger, what are your plans in terms of representation of counsel?
I filled out an application
When did you do that?
yesterday.
It's not available.
Your Honor, I was at the jail this morning and picked up probably 5 or 6 applications, and what I was told by the jail personnel was that Mr. Steubinger had refused to fill out an application. Did you fill one out, Mr. Steubinger?
That's what I just said.
Well, fill out another one, and let's get it going. I'm going to enter a plea of not guilty for you on the charges that are against you here today. Your job is to fill out another one. This matter will be set by scheduling order on the same schedule that was previously filled out. Talked about earlier. Your next reappearance date will be November 16th of 2017. Your pretrial date will be set for January 25th, 2018. There'll be a plea deadline date of February 22nd and a trial date of February 26, 2018 during that week. Those will all be in a scheduling order, and we'll proceed from there. Where do we stand on any issues of bond?
Your Honor, if I could speak, and under the assumption that we will be appointed, yesterday Mr. Steubinger and I were unsure about any sort of hold on him, and talking to Mr. McGowan, I understand that there is not any sort of probation hold on him. He gave me an address and an individual by the name of Brian that he can live with at 187 Primrose in Flippin, Arkansas. I think his bond is currently at $15,000.
1-5?
1.5, yes, 15.
All right.
You know, I am, since he is brand new to us, assuming that he does come to us, I'm unsure of his criminal history, but given the nature of these charges, given the fact that he has a residence that he can go to that is in a neighboring county, I would ask for a substantial reduction in his bond.
What says the state? Do we know anything about a criminal history on?
You know, he has a criminal history, but it's not such an issue as for us at this time. We've agreed to a reduction in bond of $5,000. We do want to report to probation and parole every Monday at 8 o'clock for his drug testing, Your Honor.
The court's going to set the bond at the reduced rate of $5,000 cash or professional, and with a requirement that he not be in possession of drugs or alcohol while he's out on bond, and that he report every Monday morning at the probation office for drug testing.
Your Honor, we would like that address that it was given to be the address he resides in, so we can verify that, Your Honor.
All right, we need the address given will be the required address. If it changes for any reason, Mr. Steuben, you need to inform. You'll need to inform your attorney so that can be officially modified. But Otherwise, you're being let out on bond to specifically reside at that address. That'll be the order of the court. You may be excused. 2017-299, State of Arkansas versus James Capel. Again, this case is down for a first appearance.
Yeah, I visited with Mr. Capel yesterday. I was under the impression that he was going to fill out an application, and that was not one that I received yesterday or today, either one.
Our understanding is that Mr. Capel has waived to go back to ADC.
Mhm.
He has waived to go back to ADC, Your Honor.
Mr. Capel, it's advisable that you make arrangements to be represented by an attorney on this pending case, regardless of what's going on the revocation. What is your intention with regard to representation of counsel?
The public defender provided me with his application today upon asking.
Can you move back just a minute and say what you just said again? Didn't come.
So nope, Your Honor, nobody provided me with the public defender's application upon asking several times.
All right. Well, I will tell you to ask again and get one. And I will direct the jail staff to make sure that you get one.
Yes, sir, Your Honor.
This whole process doesn't function well unless this gets done.
Your Honor, I've represented as public defender Mr. Capel before, I believe. I'm confident that the court's going to appoint us. If the court won't allow me, then I'll enter a plea on his behalf today.
I'm entering a plea of not guilty on behalf of Mr. Capel. This is on a charge of possession of a firearm by a certain person. The case is assigned to the Division III docket of Judge Putman. I'm setting it down for a reappearance in front of Judge Putman on August 10th. All right. Well, Mr. Capel, I expect you to have that application filled out so when you appear in front of Judge Putman next week, this matter can be dealt with an attorney in place. You may be excused at this time. Ms. Fisher is for arraignment on charges of possession of controlled substance, meth or cocaine, possession of drug paraphernalia related to meth or cocaine. Ms. Fisher, have you made any arrangements to be represented by an attorney?
Yes, I filled out the application. I have it right here. I didn't know how to turn it in or anything.
Okay, so you filled it out, but you haven't turned it in.
Yeah, I didn't know. I just brought it with me today. I didn't know how to turn it in.
All right, well, get that turned in so that it can get into the hands of the public defender's office.
Yes, sir.
Your Honor, I visited with her yesterday, and bond I know is not going to be an issue because of a parole hold that is on her.
Well, the court file reflects that this has already been transferred to Division 4. Is that?
She had an arraignment last week.
The scheduling order will be the standard scheduling order that this court is using. The next reappearance date, according to that scheduling order, will have her reappearing on November 16th. 2017, a pretrial on January 25th of 2018, and a trial set during the week of February 26, 2018. And this case is, Ms. Fisher will be, is directed to make sure her completed application gets turned in so that we get that to the public defender's office and the appointment can be made. If there's no issues of bond, ma'am, you may be excused. 2017-303, State of Arkansas versus Gary Hargett. Mr. Hargett, have you made arrangements for an attorney?
I have paperwork.
Once again, you have the paperwork in your hands, okay. All right, so you're applying to the public defender's office?
Yes, sir.
All right. Case is assigned to the, court's going to note a plea of not guilty on Mr. Hargett's part. This case is on the Division 3 docket. The court is putting it down for a reappearance on August 10th in front of Judge Putman. Mr. Hargett, the charge against you is sexual assault in the 2nd degree. It's a Class B felony. And as I say, I'm noting your plea of not guilty to that charge.
You know, I visited with him yesterday, and I believe that we will be appointed, and my advice to Mr. Hargett is the same today as it was yesterday, and that is that bond is not an issue today.
Well, why is bond not an issue?
You took 89 days already, Your Honor.
Oh, he's already, sir? Okay. All right.
And there'll be more, we're going to be filing some additional paperwork on that, Your Honor.
If setting a bond can be taken up with Judge Putman once he goes in front of Judge Putman and gets on the judge's schedule. You may be excused, sir. We have 2017-306, State of Arkansas versus Jacob Morley. In this case, I do have a petition for appointment. The court is making the appointment of the Public Defender's Office to represent Mr. Morley. Mr. Morley is for arraignment. The charges against him are possession of a controlled substance, methamphetamine or cocaine, Class D felony, possession of drug paraphernalia, a separate Class D felony, delivery of a controlled substance, Schedule 6, Class C felony, then there are charges of no seat belt, driving on a suspended license, no liability insurance. On those charges, how does Mr. Morley now plead?
And he enters a plea of not guilty to all the charges and waives a formal arraignment and reading of the charges.
Court is setting this by scheduling order. The scheduled trial date will be set in the week of February 26th. The pretrial date will be January 25th. Both of those dates are in 2018, obviously, and the reappearance date will be November 16th, 2017. Mr. Morley, you're advised that you have a court-appointed attorney. It's your obligation by order of this court that you maintain communication with the attorney, provide and stay in touch with the attorney that's been appointed for you, It's your obligation, if you bond out of jail, to get in touch with the public defender's office, schedule appointments, and then keep those appointments. Failure to do so could result in you being held in contempt of court and punished for that. So I just want to emphasize to you how essential it is that you stay in touch with the public defender's office.
Yes, sir.
Are there any issues of bond on this?
Your Honor, I believe there is a parole hold on Mr. Morley also.
All right. While you're in jail, it's simply up to the public defender's office to stay in touch with you. But if you do bond out at any point or are released, it's your obligation to stay in touch with them. You
Yes,
may
sir.
be excused. 2017-255, State of Arkansas versus Cody Joe Haynes.
Your Honor, Mr. Haynes has been appointed to us in another case, but on this case, which is a failure to appear, we have not been appointed. That's the status of his legal representation on this matter.
Apparently, Mr. Haynes failed to appear on this case for arraignment back on June 22nd. This court issued an alias warrant with a no bond hold. Mr. Haynes, you're now before the court at this point for arraignment on charges of breaking or entering a Class D felony, theft of property, a Class A misdemeanor, and criminal trespass, a Class B misdemeanor. On those charges, how do you now plead?
Not guilty.
I'm noting your plea of not guilty. Have you made any arrangements to have an attorney represent you?
I got it filled out right here.
Okay. Have you filled it out?
Yes, sir.
All right, let's get it turned in. I mean, this is ridiculous. So, get that filled out and turned in. I've noted your plea of not guilty. Court's going to set you down to reappear in front of this court. No, excuse me, it's on Judge Putman's docket. Reappear on August 10th in front of Judge Putman. You can take up bond with him at that time. You
Your
may
Honor.
be excused.
Your Honor, before we let him go, can the court look and see if Mr. Haynes is arraigned on 2017-183?
I'm on bond on this already on a $30,000 bond.
On that case as well, he'll be ordered to reappear in front of Judge Putman on August 10th.
Say it again, Ms. Polly.
What?
On 17-183.
Yes, ma'am.
Is ordered to appear on August the 10th.
Yes, ma'am. Thank you. Yes.
And at this point, the court's going to leave him without bond. He can take that up in front of Judge Putman at that time. You may be excused, sir.
Thank you, Your Honor.